Okay, and also, like Dr. Cottarella, I hope everybody's okay with me having the mask off. Is that cool? Okay, good. Honestly, I try to be very transparent. I'm from New York, so I'm honored just to seriously be following someone like her. It's not even anything that can measure up to all of us who are what we call sort of young school, new school, grew up, reading the AMA guides and continue to try to read them and learn from them. They're literally like a Bible. So she's not only been a mentor, but a role model for excellence. With that aside, I only mentioned degrees because another degree, and my mom said I'd be a thermometer. So, I really enjoy sort of the forensics like I was hinting at, and to me, that's what depositions are. So, just by show of hands, so we get some sense of who is here. Any attorney present? We can see if there's anyone. And then,
yeah, we can.
Up the volume, we
sure.
can't hear you.
Up the volume, okay. You mean me talk louder?
Yeah, please.
Okay, sure, no problem, thanks. Don't hesitate to jump right in. We're used to having all kinds of feedback. So if questions come up, please don't hesitate. Physicians, fields, can I just shout out what fields are represented today? Psych. Ortho. I am. PM&R, okay. Hi. We've got PM&R doc. Great. Okay, so with that in mind, my sense is that you all will continue to see more cases, and does anyone sense that that's starting to come? Just show of hands, raising hands, more cases. More supplementals, show of hands with any of that. More depositions. More rejections on AOE, COE, basically not accepting cumulative trauma as a given on the case. Any more of those you guys have seen? Not so much so. So those are my predictions. So we're gonna see if that ferrets out to be the case through 22 and 23. I think we know that some of the drivers there are the change in the fee schedule, but also just really a drilling down. So we thought, therefore, that it might be good to sort of cover some of the experiences. Hopefully, like none of you, I literally do a deposition probably almost every single week. And so I've only been doing this for 14 years, so I will put that out there. And I cover states like this past week. I was in Sacramento, Alaska, and then obviously here in Los Angeles. I will be, in the course of this past year, Nevada, Arizona, Minnesota, trying to think what other states, Texas, and Washington. So just doing cases, state cases, which are the IMEs, and then some of the Q.M.Es here in this state. So just to give you an idea of where I'm drawing those predictions from. So here's kind of our purpose today. I believe these depositions can be challenging, but yet a rewarding experience, but that every opportunity essentially allows us to grow. And that's what I see them as. So the whole goal today was to sort of disarm the process, dissect it a little bit, do a little bit of forensics on it, and then also hopefully just make you able not only to feel comfortable doing depots, but also to do even better on our first reports because there's going to be more and more requested of us. So what are the specific objectives today? To look at the reason behind the deposition, to also get you more comfortable in truly prepping for it, and then also understanding what some of the challenges are that you're going to face and what the genesis or the etiology of some of these questions are. And then more importantly, some things to maybe consider afterwards. If I had to pick one word about the purpose and the goal of a deposition, as much as you may love them, and just show of hands, anybody who loves depositions and looks forward to them, seriously, I mean, it's okay, and those that really kind of, and you maybe can put your hand to this side, kind of sort of fear them just a little bit, kind of feel a little bit intimidated and things like that. Okay, so two people are willing to be very honest. People from New York love honesty. These are sort of the things that we're really drilling down on. What are the filing dates? What are the injured body parts? Keeping in mind that often there can be a panoply of information that's given to you, and we'll get into some of that about what exactly these are. But the goal is really to desire and achieve some precision. You'll see that half my practice is sports, it's small organizations like the NFL and NBA, so you'll see a lot of sports pictures here, but everyone was purposely manicured for you from my photography collection and hobby. We've been filming all weekend here in the beautiful setting that we are. Obviously, AOE issues, credibility. This is a whole big one that you'll find more and more of the depositions getting into. Many of us as physicians assume and automatically take our patients as being credible, our applicant, as being credible, but that will continually be drilled down upon, and also precision in achieving whether or not that's true or not will be constantly one of the goals of the deposition. The rating and things like that are pretty straightforward. We're going to hint at things about apportionment. I think last time I did this, we did one on apportionment. So I wanted to sprinkle that in because I think that is certainly where a lot of people get sort of frustrated in the deposition process, frustrated in the report, and there's a lot of moving targets there can be. And on that note, some of these really could be subs to that: prior injuries, pre-existing disease, previous employer, subsequent employment. If I had to pick on 4 types of areas, we could put 20 in there. What would TTD dates versus PD dates versus the dates the patient actually said they left versus is this a wrongful termination case disguised as a workers' comp claim. But these are some of the types of things that are key for apportionment. Depositions are a discovery tool. You'll find me trying to find poetic words and phrases to kind of make the process a lot more humane, just like someone might consider trimming a bonsai, a tree, and the art of horticulture in that regard. But it is a legal term of art, and it relates to how the parties are going to seek information from the opposing parties and also basically do discovery. It's an important workers' comp concept, and it's emboldened in law, specifically Labor Code Section 5402, and this is obviously commonly used. And to be fair, and I listened to Dr. Laura's talk, it is an obligation. As difficult as it may be for the clients, my patients, when they're going to go to a depot, are scared. Sometimes the applicant attorneys are scared, sometimes the defense attorneys aren't necessarily scared, but maybe, depending on how people may feel about it emotionally, it's an obligation to sort of really ferret through these processes and figure out. So this is the easy part, the things that you all do all the time, and it's no big deal. You can wax and wane professionally for half a page or 60 pages or 20 minutes into a depot about your background, your education, et cetera, all these things that are very, very auspicious. As you know, these are establishing you as an expert, as credible, as authoritative, and all of those types of things that sometimes usually are dismissed relatively quickly, especially if you've already forwarded your CV or made sure your CV was sent, and hence those little types of things for the office are great, whatever organizations you may work for, that they've got an updated CV, especially if something big changes, you take over an academic position, or you decide to go into private practice, as Dr. Laura transitioned, and things of that nature can be helpful. Basically, what they're really getting at is scope of practice, but subtly it's disguised as listing out all your credentials and accoutrement. So what about from the defense perspective? Because sometimes that is often what clinicians and sometimes even the applicants are thinking about, like, what is it they're thinking? What is it that they're really getting at? I have some sense, and I can kind of meander through. So we're going to try to dissect that a bit. So some of it's very obvious. We're trying to send a message, meaning that we're serious. We are going, again, it's coming from this defense perspective. We're going to pursue this. We're going to depose the applicant. We'll depose everybody. We'll depose the applicant's mother if we have to. No, maybe not far. But with respect to really ferreting out the case, we need to be able to say this isn't something that we will take every single thing that's stated as fact. We have to prove beyond reasonable uncertainty, maybe not the shadow of a doubt, that the statements that are being given about certainly all the medical things that you all are expert in are accurate. Certainly as relates to things that relate to benefits, maybe there's a prior award on the case, a prior settlement, prior cases with other employers, and things of that may play a role. Obviously, the whole case evaluation piece is meaning that we're really sort of serious about moving forward, but we've got to really get some of these facts. Because many times as clinicians, I've certainly encountered that where the case just sort of seems to be meandering, and you may or may not be getting denials, but they're in sort of this abyss of not really being clear. And so deposition sort of set the stage for, no, we're a little bit ready to rumble. And certainly it can be a stepping stone to getting settlement to happen, because many times the applicant and or their attorney may have a very unrealistic expectation compared to a reality. So to me, they're just like a huddle situation, hence the choosing of this picture. What is their perspective on the injured worker? Again, kind of really starting to get the applicant to realize that we're moving towards trying some steps of settlement. Maybe something's been offered sort of behind the scenes, it's been refused, and it seemed to be whatever, paltry, inappropriate, insulting, however the applicant and or their attorney may have taken it. Okay, now we're stepping up, but there's more costs, as you guys know, involved in deposition, more discovery that has to be done in deposition, more time, and sometimes that alone is being done to sort of allow the applicant and or their attorney to see we're moving in towards more of a legal stage for closure, but this is going to drag settlement out a bit, and we may or may not discover things that are beneficial and or contradictory for your client. So in many ways, it's sort of a pre-settlement type of move. If people think about the analogy of chess, since we have a lot of sports analogies up here. You also have a captive audience. This is a chance to really state, many times you'll see that happen after the depo, the attorneys will agree to confer with each other, sometimes they may have done it beforehand, but it's really a chance to kind of focus in, get it separated from the paralegals, the paperwork, and all the other things that may be in the middle of a true conversation face-to-face, attorney to attorney, and really work this out. So some time one-on-one about that. And of course, there can be some risks on both sides with this. And some of the things that can come out potentially are these issues of apportionment. We'll hear this a lot, inconsistencies in something that the patient may have said to a chiropractor 4 years ago before filing a claim 2 years ago. Things of this nature are almost always bound to come out, and depositions are going to really tease that out like no before. What about after, in terms of, again, we're still in the defense position on dealing with depositions. Maybe we agreed to disagree. Maybe we fought tooth and nail. But perhaps there may be a concept here about where defense is going. We can sort of start that pathway towards settlement because maybe some things will spring up or be more clear that are problematic. It may expose unforeseen case weaknesses to the other side. And in many ways, I tell people this is analogous to what the Q.M.E. process is like when you're going through a depo. So again, digging just a little bit deeper, what are some of the reasons behind the depo? Some of them are obvious. So pressure on the witness, we're going to look at specific reasons why we need to bring a witness in. The claimant may also be under financial strain. That is certainly appreciated by the defense. I know you all may know it. You may hear it from your patients when you're more on the patient side and not on the Q.M.E. side. But certainly there are people that can be pressured to settle, and there is sometimes that need for various reasons. Just out of curiosity, in the last 2 years, have all of you probably done a situation where the patient was flown in to do the Q.M.E. for you? Has almost everybody experienced that so far? Where the patient was living in another state and they flew them in just to do your Q.M.E. or A.M.E.? Yeah, I saw somebody raise their hands. So I'd say that happened for 2021. I guess we're still in that. I had 5 of those. Where they literally willing to do that. So clearly the overtures are, let's try to move along because you've quote unquote moved on with your life, and there's only but so much treatment and therapy you're going to get in the state of California if you're now living in Georgia. That is certainly a pressure that's there that you probably perceived, but here we're just being blunt about it. Also, there's this harsh reality, which is in box 2. Most claimants don't want their current employer to know that they may have other litigation brewing in other domains, because of course it kind of can look a little bit pejorative. If that sounds crazy, it happened this week, and certainly if she's around, Erica will remember it. We both had flown in to get this case done on Thursday morning, I believe it was, and the attorney had already canceled the case. But the patient was there, and of course livid. He's a truck driver, so I'll just let you draw your own conclusions about that. And so the case had already settled between Wednesday night when I got the confirmation and Thursday morning the appointment was at 10:30. And so thank goodness I was prepping for depo. And I just hung out at the office, and needless to say, it took a lot of time to work all this out. But all that to say that part of the issue in that case really is in box 2 here, where the claimant had other cases and some were settled, and in his mind this was one that wasn't, but I guess that really wasn't the case. So anyway, clearly we often see the impact on function, what are the types of things that people are doing. I'll pick a case, and maybe you guys have seen that. We're literally doing the depo, and I don't know if any of you guys had to watch Sub Rosa video during the depo. Does that ever come up? Yeah, I see somebody raising their hand. So we watched the claimant wash not 1 car, but 2 cars, and these were both SUVs with shoulder and upper extremity impairments, by report, we'll put them in quotes, for 20 minutes by hand. This was not with a hose, this was not through a car wash. So clearly, that type of video is really critical. Now, to be fair, because while that might sound like an easy slam dunk, those of you that are very familiar with dealing or negating Sub Rosa video, the claimant's impairments weren't so great, obviously, but the ratings also weren't, at least the preliminary ones. And the person was working part-time at a McDonald's at the age of 60. This is a woman, actually. And she'd worked there 15 years, and that was the time frame she worked, 4 hours faithfully. So one of the things that we brought up out of fairness was the type of work and the type of activity that the patient was doing on a, or in this case, applicant, on a cumulative trauma, on a work-related as well as cumulative trauma, but clearly you have some apportionment for capacity. Yes?
Did they just spring this video on you?
Yes.
Okay.
Yeah, it had just been acquired, you know.
You can deny watching it, right?
Sure.
That's what I did, because they were
Sure.
like, I don't even know who this patient is. I haven't seen him in 2 years.
Right.
Like, send it to the other attorney
Sure.
and make sure this is the guy, and then send me the Celrosa video.
Right. And we're going to get into on some of the prep stuff, that exact type of point. You have the ability always and should. In that case, I luckily did remember because it was so relatively rare. When I'm in Florida, it's different. We have a lot of people who start taking on part-time jobs in their senior years. But I'm in Northern California, what we like to call Silicon Valley, and so we have a lot of youngins, so to speak. So we don't get a lot of cases of seniors that have a secondary job, especially one physically demanding like that. Nevertheless, but yes, certainly you have the right to refuse to remain silent. Information about earning capacity and things like that may come into play. So a perfect example with that is I've had a couple of cases that have involved attorneys or other professionals or chiropractors and things of that nature. And certainly the fact that the person can continue to work or not work can play a much larger role in getting the case settled or not, or the pressure itself. And then just demonstrating thoroughness. At the end of the day, like it or not, the defense attorneys do have someone to answer to, and that's at the insurance company level in terms of maintaining a contract. And these are just the harsh realities of the finances behind it, just as if we have people that we feel we have to answer to, our staff, our family, employees, things of that nature, employers. And so there is a need to demonstrate the thoroughness and not just be willy-nilly, oh sure, let's just put it on through. So I think, out of fairness, it's important to sort of appreciate that side, because initially one can certainly potentially feel like this is an attack or witch hunt on your credibility or your completeness. With respect to, I put down tic-tac-toe because I think that this is really one of those subtle things that plays to apportionment, probably the second time now that we're mentioning it. What's that prior history? What are those prior injuries and things of that nature? Is there subsequent employment that's at play? Many times, some of those details the patient may forget or not mention or not really get into. Pick a case, this was only 2 weeks ago, and so it was a firefighter, and counsel was kind enough in the letter, which, as I'm sure you guys are probably noticing, the intro letters are getting longer and longer if I get them, to point out that there was a secondary job that the firefighter had. In addition to the primary job. So thank goodness, because of not at least overlooking that, we really went into a lot of detail, and it turned out that he did something that not too many people in their lives get to do, which is to sell fire engines. And as he explained in a lot of detail what that process is, I sell about one a month. I don't drive it. I don't use all the mechanics on it. He said just like selling most planes and other gigantic vehicles of that nature, yachts, you don't really do a lot, much more than talk on the phone, and when you finally get to show it, it kind of speaks for itself, and the department kind of looks there and torques and things like that. So even though he did in fact have a second job and we had to think about a potential subsequent injury from the date that he had left the fire department officially to go into sales, that his physicality, so to speak, in the second job was not as great as may have seemed on the surface. Conversely, we've had people who have full avocations, hobbies, and businesses that they're running that are very significant, like running a restaurant or something of that nature. What kind of issues have happened with prior employers? Again, apportionment issues may come into play there in terms of residual impairments and things of that nature. And certainly prior accidents and things of that nature, because again, many times when you're with that patient, they don't always give a lot of that detail of exactly what were those dates of injury that you had with a prior MVA 6, 7, 8, 10 years ago, what exactly were the body parts that were claimed on that, how exactly did that filing go, what was the treatment, and what was the settlement, if any, and more importantly, probably one of the most important things that they often will not get into, at least without really being pressed, is what are some of those ongoing residuals, because many times they minimize it, like, oh no, my neck was totally fine, but that's not what the records may show. So again, while this gets at apportionment types of issues, this is where some of the depo is going. Okay, in the morning. Sure, it's still too low? Okay. Take it up even more, all right. So what about from the applicant's perspective and the reason why we might be doing that deposition? Again, we're looking at the cost versus benefit, the monies that may have to be paid out. We're also beginning to set up that fact of, okay, if we were going to have to go to a trial type situation, as we know, most of this can be done in the depo stage, we've really got to sort of counterbalance out what are the witnesses, what is the applicant like, what is the doctor like, and things of that nature, and try to move these settlement discussions down the road. Certainly with respect to discovery, many times, as you all know, no doubt almost all of you have at least had one case this year where there were key medical records that needed to be obtained and they didn't exist. So many times depo is the only way to get that. And again, this is of the applicant. Why are we deposing the applicant? To try to get some information about that old car accident or that second job or things like that, where they say they went to an outside entity and those records can't be gotten back for this. So moving on to the transcript, probably one of the key take-homes there is that it's got some key uses. We've got to review it with respect to the workplace injury and thinking about PD and things like that, and then also to try to make sure that the patient is being, the applicant is being consistent throughout. So probably if there was any sort of key takeaway, it's certainly that. If you have a depo transcript before you sort of finalize your, you may do it somewhat with impairments, but more so obviously with apportionment, really being aware of some of those statements that are in there, because many times things that were in that situation where they are under oath and they sort of are pressured to remember and they really are drilled down, and as often may happen, although no one here may admit it, they may have more time. That depo may drag on 2, 2.5, 3, 4 hours, be broken up over a couple of days, whatever the case may be. The person may stop, wipe their brow, go get some water, go to the bathroom, come back, whereas in seeing you, you may not have quite as much time to really drill down. So definitely don't overlook those. And of course, the defense attorney only has one chance to do that depo, so it's worth looking at. What about the treating physician? Because this is sort of now where we come into the process. So there can be some significant benefits with respect to pushing towards settlement. Obviously, they've already got your report beforehand, and we need to essentially clean up the record. And that really is, at the end of the day, what the purpose is. Not necessarily your report, because of course they're all perfect, and you've really put a lot of time and effort into it and things of that nature. But there may be some factors that we've already hinted at that may not quite be as clear to you at the time, or couldn't have been clear for various reasons. Records came in after your report was issued and so forth and so on, and you didn't have the pleasure of those. And no doubt all of us have had a situation where at least one document appears in deposition that neither counsel has had, and as the good doctor pointed out to us, we always have the ability to agree to review that after the fact, should an old AME show up or something of that nature. With the NFL for sure, many of those cases, you guys may know, go back to the 90s and they're just being settled out now. So there can often be a lot of reports from Combine and things like that that really give a lot of detail. And I only bring that out to say the same thing may exist in another record and or a prior Q.M.E. you may feel did overlook X, Y, and Z. So clearly taking a look at those are very critical. With respect to the applicant not being there, we can all appreciate that. It kind of really removes that bias. The applicant's in front of us or the patient's in front of us, and there's a certain sympathy or bonding or connection that may occur. That certainly at some level certainly needs to occur, at least just to not have the patient feel like they are in a deposition even though they're technically doing a Q.M.E. But certainly outside of that situation here, you're more free to speak some of your true impressions and concepts. Yes?
Is there a difference between a subpoenaed deposition and a non-subpoenaed deposition?
You mean in terms of the doctor being subpoenaed?
In terms of what what message is the Q.M.E. getting when they get a subpoena for the deposition versus them just requesting a date to have the deposition?
Sure. Well, I can throw it out to the audience, but my honest impression is that these subpoenas are always negotiable as long as you respond before that time, wherever it's coming from, whether it's coming from the DOJ, the state, other investigators, a defense attorney. If you know that it's Saturday at 10 o'clock, you're supposed to be giving a lecture at La Terrania, maybe that time doesn't work for you. But I should not call them on Monday and say, I missed that subpoenaed date. I mean, just out of, so, and has anybody else had an experience where they either had to sort of rearrange the time that you were subpoenaed to be deposed at, or things of that nature? Okay. But that's typically what I do. I quite frankly, ignore the date and call and really set it up for the schedule. But that's what I take it as, okay, they were really serious because for whatever reason, they felt like they couldn't go through the typical channels like we do with the group, and they send it to me directly. And that happens a lot of times. They find my address online and send directly to me and send the subpoena my way. And so I see it as a date scheduling request that's very serious, of course. This probably little take home here exists too, that most applicant attorneys are focusing on their review, and so somewhat, not to be mean, but sort of their interpretation of the medical issues, and they're not necessarily looking at the case values. And what I mean by that is that they may be relatively dismissive of prior injuries, prior workup, prior treatments, prior settlements, the list goes on, because they are focusing on the history that they got here, and it sounds very good, and the person was with the employer 6 years, or they had a very physically demanding job, and things of that nature. And or to be fair, in their one or two, because they're certainly not talking to the applicant every single day or every single week, in their limited interactions with the applicant, they may not have realized that all these other records are slowly coming in or exist, and or had the chance to really drill into them and see. And I don't know, just check, show of hands so I don't throw out comments that aren't true. Have any of you all started a Q.M.E? You didn't either have the AA or the DA letter present, it hadn't been received? Yeah, pretty much everybody's nodding their head. I mean, so certainly that's part of it as well. I mean, it's a tremendous game of almost telephone, but getting all these documents together, including one of the most important things. And so my mantra, and everybody may have a different approach, but I literally read that with the applicant. I really do, because I feel like it's part of the entire package. There's nothing now to be hidden. There's nothing that's going to be said in there that's any more inflammatory than what the applicant's already heard if they've been deposed, and or they will hear if they get deposed, and or from their attorneys. So that sort of forces both of us to really be aware of the legal. I like to tell them, we're going to focus on the medicine, but I can't ignore this literally elephant in the room by not having you be aware of where defense is coming from. And so again, it also helps paint a very poignant picture in my mind, especially when they have been punctilious and the letter is 2, 3, 4, 6, 8 pages long. I'm going over multiple injuries, multiple dates, or this or that, other issues that may exist, the subsequent employment, like we talked about the firefighter, to make sure that that gets covered. What other types of things more specifically are they trying to do? We're trying to give the defense an opportunity to clear up their case and make it stronger. They realize that doctors can flip, as you guys probably know, unofficially. That's something that we really don't want doctors to always do, but certainly there may be some information that comes to light. And as, again, was pointed out by the good doctor, it really is, I think, and again, I put it out as just my 14 years experience, compared to many of the lecturers today who are double, triple the amount of time I've put in. Best that if you really sense that you've got to make a major change in apportionment, rating, or do something complex, like put together a CRPS rating or do a sensory rating off the top of your head, although I'm sure all of you, took quantum physics and did really great in AP calculus and things of that nature in junior high school, be willing to admit that you can take the time also, since you are so wizard at it, to not do it off the cuff. Because they will want, remember, you're in a depot, they will want to hold you to some of these opinions and conclusions that you're changing up. And to be fair to the applicant and the applicant attorney, probably even more so, it really, to say the least, in terms of like getting caught off guard with the Sub Rosa video, catches them off guard for major swings to occur in the midst of it, short of things sort of really being seen as obviously complex, like I had with the Sub Rosa video. These are opportunities to, of course, push the settlement along, but by the same token, you are there to really look at all the evidence and the preponderance of it, and you may need more time than typically, depots an hour, hour and a half at the most. It's not that much time. So now we'll get to sort of the prep specific stuff, and on your mark, get set, go. Some of these things are very obvious. Looking at the records, let's say this is the night or a day or two before you do your depot, looking at the records you received and organizing things and whatnot. And keep in mind that obviously with IMEs, and I just threw that in there because some of you all may do that on the side as well, and I'm just curious, have you ever been involved in a case with an attorney that you could speak to and not been able to reach the attorney for days, if not weeks before a trial, and literally only been able to speak to them just seconds before you had to go on the witness stand? Has anybody had that pleasurable experience? So clearly you all work with some of the best attorneys, and maybe in San Francisco, we're just Harry trying to figure out how we're going to pay our mortgage. and they don't get that kind of time. But it can occur. So I always encourage that, obviously we'll have looked at your reports and things like that, but just for a general 30,000-foot view, it can be helpful when working with counsel directly, where you can do that, to be able to have that opportunity to go through that. I did this in a case, we did this case I think out of LA, where we were dealing with United Airlines. Very, very seasoned attorney, very, very complex case, high seven figures involved. So, clearly it's very helpful. And in those cases, of course, you're talking about pulling tons of literature. I think I pulled 31 articles that I really had read to be able to go into that depot situation. And I think we were there, it was a short depot, so I think we were done in about 5.5, 6 hours, something like that. So, and not a longer depot. So just something to keep in mind in terms of getting prepared. You're also trying at some level to kind of get their style. As you can imagine, so sometimes in the background questions, they're going to drill into exactly what dates you did your internship in surgery. So clearly, if we're starting off that way, it's going to be very punctilious, to say the least. And then more importantly, you're just trying to essentially have a timeline of the case. And there may be, and they'll often ask you, do you recall this client that you saw 17 months ago? No, you may not. That's okay. You don't recall the client. It's better to be honest and clairvoyant about the things that you don't know. But these are some of the kinds of things that they're going to often be getting at, which is, what are those filings? What are the specific versus CT issues that may exist on the case? Is there overlapping injury? What are the exact dates of employment that we're talking about? Because in cases, and I'm sure some of you have acted like an AME, or at least had a case even as a Q.M.E. that was like an AME, you may have 7 employers spread over 14 years, sometimes with overlapping or not, depending. You may have companies that merged and got acquired by other companies, and therefore the insurance company for the same patient that stayed at the same, let's say Safeway is a perfect example, has changed 2 or 3 different carriers. And so things can definitely get muddled and complicated quickly. Here, these are those basics. To tell the truth, you are under oath, and not to be funny, but if you have a certain way that your things are processed. So what do we mean by that? Because the doctors are like, of course, I always tell the truth. I live to tell the truth. It's all my whole life. I've done nothing but lie and tell the truth. I mean, tell the truth. You take notes during the case. And so for me, and I'm not saying everybody has to go this way, but I'm doing them all into the report real time. It's a time efficient things, but it's also a paperwork trail piece. Because if you do write those range of motions down on a slip of paper and they get transferred, but then destroyed, and that's fine to state that. So be it. But certainly, I would call it the olden days, but back when I was first doing this, and copious notes and things like that, and those didn't get destroyed and they got put into the record, but many times they didn't go off as part of the Q.M.E. report. And they have 4, 5, 6 pages of notes with that has to be admitted that yes, I do take notes, I did do my range of motion measurements, and we did save that, and it's available, we can get it from the office. So for sure, if you have a working document that, so to speak, isn't destroyed real time, it is best that you keep it, have the office receive it, and make sure that it's filed as something that can be available. You obviously don't often send that type of chicken scratch. Sorry, I'm sure your handwriting is really quite hieroglyphic. But to the requesting party with your report, but by the same token, certainly make sure it's saved. Likewise, and these are obviously sometimes outside depots, IMEs and things like that, every single book, reference, article, things that you read, even Sabatru, if you talked to someone unofficially off the record about this case that you're in, realize that that is subpoenable, that is information that was used to put the case together, it will be requested, and you can't, and the reason why, what? And you all know this, you can't make reference to that. You can, well, according to Dr. Laura, okay, wait a minute, you didn't, that's not mentioned anywhere in your report, who is this doctor? So forth and so on. Or according to, such and such an article, or my academy, or the guidelines, somebody was mentioning MD guidelines during the last talk, so forth and so on, or you procure it. No, that has to be mentioned from the beginning that you're going to be making references to other sources and things like that. So that's what we really mean by tell the truth, is realize that because you're under oath, you really want to seem very transparent and realize that any pieces of documents that you're creating, using, and or putting your report together with, that if they are not essentially destroyed at real time because you transcribe them or they get transcribed, that if they exist, they are subpoenable, and you have to mention that they do exist. Again, obviously we're not going to argue, exaggerate, speculate, so it could be a whole lecture unto itself. Many times this is one of those little clues. You will get the objections, and we often tell everyone to listen to those. I'm trying not to interrupt them, but realize that essentially opposing counsel, whatever side you may be on, is giving you a clue that there is something about the question that probably is speculative, inappropriate, not completely legal, whatever the case may be, and that's somewhat of your clue to take advisement to say, okay, I'm not going to, you're still going to be allowed to answer, but I need to realize that I could be speculating, and what exactly does that mean? So that sort of goes to the next thing. Let's pay attention to the question. Let's not anticipate the response, although sometimes that's hard not to do. And then, like I said, really paying attention to the objections.
Hey, Doc,
Sure.
before you go on, can you give an example of that? Because can you give an example of that, what you're saying?
Sure. Which, and what, when you say that, be more specific?
When they say object, and what you would say at that point.
Right, so often the objection will be put on the record, and then they'll say, but the doctor can't answer it. So a lot of times it will speak to, we're going to get to in one of the slides, but it will speak to the hypothetical. Let's say that you had an obese patient that had back pain. I'll pick a question I had this week, and they had sciatica. Could they work and not complain of pain? And the easy answer to that is yes, because we all have patients who have sciatica and radiculopathy, and I'm sure nobody in this room may, but if someone does, they will get up or stand or move or take a medication or try to manage and wince with the pain, but over time they do learn to adapt to it. So the answer is that yes, it is possible, because there's often driving in the question the concept that this couldn't be the case. There's no way this person can be working with such pain, or as you guys know, the converse. This person couldn't possibly be able to, going back to Sub Rosa video, take out their trash, the typical things you'll see in a video, take out their trash, go and stand for a bit and talk to a neighbor, go run an errand and things like that. If they're saying, which often they have put that on some of your questionnaires, they can only walk 10 minutes, stand 15 minutes, and sit 30 minutes. And here they've filmed them at a public space, let's say the DMV, for 1 hour, waiting, and show you that video or say that information. So all that to say that many times they will try to needle you into something that is a little bit unfair in terms of a question, and it can you'd be speculating, and so you'll often hear that, like, that question's that question's speculative, it's hypothetical, it lists facts not entered into evidence. These will be the kinds of things that you'll hear the other side saying. And again, it doesn't mean you can get a law degree overnight or in a few seconds and you'll still respond, but just be a little bit cautious sometimes in how far am I going to go? Do I want to try to give a lecture on the physiology of gait to explain how patients are actually capable of walking despite sciatica and not showing antalgia? Or do I want to keep it really simple? Yes, I have plenty of patients that work with severe pain that's documented objectively, like in the case of an EMG or something of that nature, and it is possible. So go ahead.
I just want to make a couple of comments.
Sure.
And stuff. I think it's really important to remember to slow down in your deposition. It's very easy to get caught up in it and get anxious and just keep talking. And so slow down, take as many breaks as you want. Remember, you're entitled to a break. If you get a difficult question you need to think about, stop, take a break, go to the bathroom, get a glass of water, think about it, write it down, and then answer the question. And that's also key, because listen to the question carefully and answer only the question that is being asked, not what you think that they're asking or hypothetically what you want them to ask, but exactly the question that is presented to you. As physicians, we're all guilty of wanting to explain the situation and talk about it and help somebody understand. And that's fine, but that's not what the deposition is about. Like you said, the forensic examination of the facts that are on the table that they're trying to evaluate. So that's really important to understand and remember. So.
Yep, absolutely. Yep, I agree. And some of that's hinted in this first comment. Don't respond. Sometimes realize, okay, they may be taking a pause, looking for various facts. Wait for the actual question. Try not to speak over the other presenter, the other attorney. If they're going to fight, and you name it, we've gone off record plenty of times and gotten details ironed out. Sometimes I'm privy to those conversations, sometimes I'm not. So it's always very interesting. And we've certainly had cases, and have any of you where they said that it sounds like you're attacking the doctor, it sounds like you're you're questioning the doctor's expertise, or basically like undermining because the other counsel is so vociferous. Any of us had that kind of experience where you hear them basically call each other out and say, okay, they're badgering the witness, essentially. Right, done a lot of depos, there you go. Yes, as the good doctor pointed out, choose your words carefully, give yourself wiggle room and or, like you said, a moment to be able to figure out what it is you want to say. Along the prep is the obvious. You do want to be yourself and you want to know the case. And here I hint at it, but we'll try to put an exclamation point where I put down, know where to look them up when needed. So a perfect example is that you may recall that the MRI had enough evidence that was indicative of radiculopathy because you decided to go, let's say, into DRE3 versus 2. You didn't have an EMG, but the clinical examination seemed pretty cogent and they had a relatively defined dermatomal sensory deficit, let's say L5S1, and you had an MRI that showed a lesion at that level. So you essentially believed that it was not unreasonable, especially if we went the lower, we'll go with, that you went with a lower rating on DRE3, you went for like a 10%. To give it, and yet they're trying to often bring you down to a DRE2. I probably get a case like this every single month on Depo, where they're really trying to push it back because obviously it's a few more points in their way. Let's go back and go over the MRI. Let's walk through how I got my rationale, because maybe you use some of the typical verbiage that's there, like asymmetric motion, which I rarely see a patient with asymmetric motion. So some of those criteria that are listed there are relatively vague and not commonly seen. So it's worthwhile to go back through. And then another little hint along those lines is page reference. Where are we? Okay, you're on page 32. Oh, let me see. So Dr. Laura's note on page 47 of her excellent summary that was 1,500-page record review that she did. I see here, wow, back in 2012, it said the patient did have a back pain and was sent for chiropractic visits. Okay, so in other words, trying to put everybody literally on the same page. The court reporter, because you have to keep in mind that they're also trying to keep up with this. They don't have the deposition transcript in front of them. They don't have your report in front of them that may be 10, 20, 90 pages long, and the ability to quickly jump into it and see where you are and what the reference is. So many times when we need a point of reference, even if it is oh, okay, I wasn't aware that they had an allergy to GI meds noted on the initial intake by the primary care doc, and now it's an issue because the pain doc, will pick on us, gave the patient a strong Motrin, let's say 800 twice a day for 4 months. That was missed because it was in a much prior record, and now it's being sent in as something that can be claimed. Let me go back through where in my record review that is, just so it really helps, especially the court reporter the most, but it also allows your deposition record to be very specific so that if you are someone who goes over them carefully and wants to see that you weren't misquoted or things weren't written incorrectly or names were spelled not phonetically, to be able to know point of reference. Okay, which one are we talking about? Because especially if it's a very detailed record review, which I was picking on that, 6, 9, 1,200 pages, it really is helpful to be that punctilious to say, okay, where are we? And likewise, if you have multiple reports, you've issued 3 or 4 reports or a couple of supplementals, or there was a prior Q.M.E. on the case, and so that's a 30-page report itself, and so let's go to that point where Dr. Miner issued a rating based on it being a level 2, and the patient appeared to be permanent stationary at that time, let's say 2018, you saw the patient in 2020, you bumped it up to level 3, and now it's 2021 and you're being deposed. Okay, why are you coming up with a 3 versus 2? Let's walk through that carefully, because that's what you'll see the attorneys doing every step of the way, laying the foundation. So likewise, I think it's helpful to mimic the same behavior, saying, I know how to rate a radiculopathy, and 4 doctors used that in the notes over the last year that they had them, including interventional and an epidural worked. That probably is a little bit more hasty in kind of getting at what you stated. Yes, that's a true statement, that an epidural can be considered a diagnostic tool as well as potentially therapeutic, but let's walk through the medical records as to what Dr. Miner stated, how she came to her rating, and maybe what new information may have occurred in those 2 years that made it more clear that it should have been a DRE3. So along that line, we have down here, be very comfortable, and I think you were hinting at that as well, to defer to the appropriate Q.M.E. If these get to certain issues, and I put them down since we have a lot of those doctors here today, psych, internal medicine, headaches, things like that, many times what I call these add-on review of systems types of cases, and you may consider yourself an expert, but it's not your board certification. Don't feel uncomfortable, even though we know you may easily come up with a headache rating that could be 1%, and it's not that much to move the case along, so to speak, to opine in that area, because you treat lots of patients that also have concomitant headaches, or you've gotten a TBI certification in addition, or you were a neurologist previously, but then you converted over to something else, but you keep up that boards in neuro, let the headaches, let the sexual issues, whatever they may be, defer onto the other appropriate specialists, despite whatever it may do for the process. Correcting statements, this is sort of post, is okay. I think you were hinting at that too, to state that you don't know, or you're not sure. If I don't have an independent, that's often one of the first questions. Do you have an independent recollection of this applicant? And often the case is no. So I'm just honest about it that I don't. And I don't try to take that as something pejorative on me or the client, that it may paint things a little bit negatively, but kind of like what you're saying, stay calm, don't go too fast, you want to be confident. And this, I was hinting at, let's not be so quick to pull back on your ratings, pull back on the credibility and things of that nature, or your apportionment concepts, especially if you've touched on them. It's very reasonable, and that's not saying you may not change your opinion. I'm just saying that doing them on the fly in depot may not always be the appropriate time, and it's important, just like you're pointing out, to stay cool and say, okay, gosh, there is a lot of information here. I hadn't read the 6 AMEs and worked out all the different ratings and seen body parts that overlap or don't, and taking that into consideration with respect to how I subbed out a prior rating that was issued. Or any of you all doing SIBTF cases yet? So, oh yeah, so some of those types of cases, they're typical things that AMEs see, but certainly that will often be the case. Certainly when it was in NFL, it really was, because most of these cases, like I said, are 90s, early 2000s. It takes a while for them to work through the whole disability and medical system, and by the time it's getting to the state, these cases already usually at least have 10 years on their belt, and many have 20 or 30 years. So you can imagine the amount of records, and NFL keeps very, very good records, despite what people may think to the contrary. So there's can be a lot of facts to sort out, and trying to do that at the last minute or during a depot. You often haven't scheduled enough time, they haven't scheduled enough time, and you really don't want to feel flustered and trying to get out the calculator. This is something that I had stated, so I got to it a little bit early, but making those page references. Oh, okay, we're on page 47 of 52 in the August 2020 report. Oh, okay, I see there's a notation here from the chiropractor in 2012 stating that the patient was in an MVA in 2011 and that they were going to start treatment, but I don't see any more notes. So just, oh, there's a gap that happened with the depositions in the last 2 weeks. One of the key areas we needed to focus on, 2013 and 2017, we had absolutely no records, even though they had been subpoenaed. And that was certainly critical during a time the patient on depot, the applicant on depot had stated that they were receiving XYZ type of treatment. We didn't have those records. So pointing that out, saying, yes, I do see here there's a gap in my record review between 2013 and 2017. You want to, of course, try to follow the line of questioning. You don't want to automatically in your mind blow off the defense attorney, no matter how serious or mean or intense or whatever, or laid back they may seem to be. You really want to try to follow along, and then certainly articulate what you're saying. Hypothetical questions, these are going to assume certain facts. They're going to essentially come up with a situation that technically and legally you may not really necessarily have to answer, but again, opposing counsel will make that opposition or make that objection, and then you can listen to it and then respond. These are always tricky kinds of questions, and it's not always really clear exactly why they're being asked. So realize that, yes, you may answer the question, but the goal for sure, like the attendee pointed out, is to really be fair and keep that answer very short, because we are often way out on water, and even though you may have vast experience in those types of cases, like we said with Ridic, the goal isn't here to try to give a medical lecture. It's really to try to keep the answer very, very short. So listen to the objection, consider your answer. Often the line of questioning really needs to relate to your interaction with the applicant, the review of the facts. So basically, like you said, we're sticking really with what's in the deposition. This isn't the chance or the need to go too far afield. It really can cause a lot of challenges. So I will often, and this will happen if we need, and you've got to reconsider, let's request an agreed upon time frame to submit a supplemental or to address the 2 or 3 questions that may be outstanding, 14 questions sometimes. Let me request the opportunity to evaluate the claimant. So often these things, at least I'm doing, usually near the end, before they say, let's go off record, or are we concluding, or the opposing counsel says I have nothing further to ask. Many times that is where I will point this out, or if it seems clear that we're heading towards that cross point that I need to bring in that the applicant hasn't been evaluated in over a year, or did a Zoom interview and it wasn't face-to-face, and that my opinions cannot be finalized without that. So these are when I'll request a supplemental. I'll reconsider the apportionment, but let me look at all the facts entered into the evidence. I will look more into the prior injuries, the accidents, and kind of aggravation versus a temporary exacerbation. I'll review additional records if they become available, the video, like you said, and things like that. So I think the takeaways are that we're trying to achieve really a definition of how credible a witness is. But for those of you who've really delved deep into forensics and applicant and jury selection and things like that, you'll really find that most us as physicians are really ill-equipped to really fully judge that. We may have our own sense of a bias. Okay, there's a financial gain here that should be obvious, and therefore the person may be malingering or saying things that aren't really true. And then there may be a different mindset that you have that this person worked at this job many, many years. The repetitive, cumulative nature of it should be pretty obvious, but maybe it isn't. So really trying to establish complete credibility is difficult to do, I believe, in such a short period of time. I mean, you do need time to really review the medical records and look at a preponderance of the evidence before automatically. And I say that only as something that often we may see in occupational med. I'll often get a report in that the claim has been denied because somebody saw the patient in occ med for 2 or 3 months, something against the doctors, but I always try to caution them about getting into issues about credibility and state that there's no way this could have been an industrial injury, so we'll pick on COVID. They heard that the father and the family was sick and from the patient, and now they're saying they got sick at work, and they're like, this is, we see there are no issues, this is not an industrial case. Or another one is where you'll see a 0 rating being issued. It's almost a given that most of those are going to be contested by applicant attorneys if there's a likelihood, not even 50%, it's going to be that high that there's a better rating could have been issued. So again, I think that we need time to really review everything, and we shouldn't automatically discredit the applicant. There is a certain level, and many of you guys are seeing this. I'll just get a quick survey on this last question, where essentially it seems like it's a wrongful termination suit, but it's really disguised as a workers' comp claim. So in other words, the person just coincidentally happened to file a CT claim the day that they got fired, meaning that that's on the date. So they may be filing today, whatever, December 4th, but it goes back to December 3rd, 2020, and it just happens that I was also let go on December 2nd, 2020, because it was a seasonal slowdown. Has anybody seen those situations where it kind of appears, that there's a wrongful TI? So that's a lot of what defense is really getting at, because as you guys know, it's an employer.
The other way,
Right.
somebody can file a workers' comp claim, and then they can get terminated later on.
Sure. Oh, sure, yeah, right. The retaliatory piece, sure. Right, but it's already been filed. So the applicant doesn't have quite a big road to go up exactly with credibility. Whereas if they've been let go a few months and or a year, it really, while there still may be a basis, it gets harder and harder. And as you guys know, and no doubt you guys obviously review all your records carefully, in cases where the patient sought outside treatment, they're doing it often to avoid retaliation. But when that CT claim gets filed, and I just had this case, lady, 40 years with AT&T, she filed it about 6 months after. All of her care up until 3 or 4 months ago was outside through Kaiser, and so now she's bringing up a CT claim, and you can imagine how it looks. It looks like a wrongful TI claim. So anyway, these are things that do come out, and it's important to realize that can really get at the client's credibility. Go ahead.
Well, that's the way it comes out, but at the same time, that's what the attorneys say, it has something to do with us.
Well, but to a certain extent, though, but like I was hinting at, it gets at the applicant's credibility. So what they're going to do in those 40 years is dig through all those records that came from Kaiser, whatever we could get, let's say it's only typically about the 90s, and see how many times was a patient came, they had back pain, what kind of workups did they have, and things of that nature, or neck, or so forth and so on. And in any of those, was there a car accident, or was there something else? And last but not least, did the patient ever state that, I always say patients are very hard and bad habit, but I see them almost every day. So have knowledge or enough knowledge to have filed a workers' comp claim. Even if the applicant states that they didn't know it was work-related, but in reality they were afraid that they would get fired and or there would be retaliation. And it seems reasonable. Why? I had a prior carpal tunnel and it was a claim. I had a prior ankle injury. I had a car accident back in '89 and there was a settlement for $5,000 on it, you're somewhat legally aware. And so I don't want to use the word pretend, but to come across as I'm not aware of anything legal and I'm just, so again, it's credibility. Why? Because they're going to try every nut and bolt to destroy us, but also to destroy the applicant, and it doesn't look good. So you're right, it's a challenge that we face. Obviously, Kite, Guzman issues and things of that nature and your impairment issues don't typically come up on the average reviews, but on those more complex cases and things like that, you're going to be questioned on your analysis, you're going to be questioned on some of your math and things like that, so do keep in mind that that's going to happen as well. And then last but not least, and we'll end with this little quote that I often try to give my patients. It comes from somebody I know very well that I grew up with all of my life. Let fear, anxiety, or despair encourage the prepared mind. So many of my patients that have concomitant anxiety, because we see a lot of chronic pain in ortho and the kind of cases I get, sports injuries, really frighten the patient at the end of the day. That often not only plays a role into the anxious state, but in terms of prepping for a depo, there can and there should be, even in giving a lecture, a certain level of anxiety that helps you say, okay, I've really got to be prepared for this. This is not something I just totally wing. And so that's often a little pearl that we're often trying to give to our patients too, because for so many of them, they're overwhelmed and they're stressed out, and how am I going to handle the finances, and how am I going to be able to deal with this, and why is the employer attacking me like this, and I can't believe I gave my life to them, essentially, and my body, and now this is how I'm being treated. And I'm talking about police captains, senior law officials, and people who really put in time and have enough austerity and things of that nature to really be able to feel dismayed or betrayed. But at least for us, our weapon really is, like you said, staying calm, staying cool, answering the question asked, and not being, how should we say it, contentious. With that, any questions?
Yeah, I'll just go back to these questions about who's asking about subpoenas or no subpoenas. I think sometimes it's just basically a formality, basically just making sure that you show up at a date or time, or whether or not you get one. I would let it sway you one way or another. But I think most attorneys would be very reasonable in terms of like you have a conflict and plenty of time in terms of rearranging it. I just also wanted to say a couple other comments. So it's like, depositions are very much also a psychological game. So
absolutely.
You can be very easily manipulated if you don't recognize it. So these questions, leading questions like, isn't it true X, Y, or Z? Several leading questions or compound questions. So they ask two questions instead of one. So be wary of that and understand when you're being manipulated. And I think the key is that you're the expert in that room, in your field, and just have a rationale for why you reached that finding. And that's kind of my comment on that.
Sure, and I'll just point out, and this happened this week. The attorney, and this is the applicant attorney, after the question summarized my statement and added the word ever at the end of the statement. And I agreed just to underscore and not over-reiterate what you're saying. Many people would say that lawyers are wordsmiths. Every single word often has two meanings in terms of where they're going and then what you may be able to legally interpret what the word means or we can agree upon means. So understanding that, likewise, too, we have to somewhat be as punctilious but also nefarious in being careful to not get drawn into things that are very vague or unclear, but also being misquoted, because often that will happen where, like you said, there's a ambush situation that can be occurring on either side to sort of really railroad you sort of down one way or say that you said this when in reality you didn't. So especially with some of the questions, if you really listen carefully, you'll see that sometimes things are being thrown in there that may not apply to a specific case or may overextend. In that case, using that word I thought was overbroad and not what I stated. So really this is that whole paying attention and realizing, and if that means you're making some notes as you go along, that's fine as well.
The other thing is, it's okay to say I don't know.
Right.
I mean, physicians, we're always self-conscious about wanting to know everything. When a friend asks us about something or other, and we want to explain it, and, but it's okay to say I don't know.
Right.
Okay?
Right. Well, I reserve the right to review this later.
Yeah,
Go
this
ahead.
goes to a different topic. We make a date for the deposition, and we tell the party that is making or that is requesting the deposition what our fee is, and we're going by the ML204 fee. And they say, no, we're going to pay you less than the ML204 fee, or I just had one where they didn't pay me at all. The date comes up and I said, I didn't get paid. I'm not gonna do the deposition.
Sure.
Is there recourse back on the doctor for not doing the deposition?
No, if you have it set as a standard that you need to be paid before you walk in the depot, you know, it is what it is. That, not trying to do an advertisement for anyone, but I know that that's why a lot of people are organized and like, you know, med legal experts, because some of that can be handled and not seem so in your domain. But I literally, has anybody had this experience where literally counsel wrote a check out at depot?
I made him go to the bank.
Yeah, right. I've had counselors write it out at depot because, as you know, the applicant can't pay, meaning they will tell you they don't have the money to pay, and defense doesn't want to pay. So depending on who requested the depot, but obviously legally, once it's been subpoenaed and written and into the record, so you never have to proceed without that. But sometimes getting into all the details of has it happened in terms of the payment is up to you kind of working with the office, because it really is frustrating during the beginning of a depot to really try to say, okay, yes, no, I'm definitely ready to proceed. I mean, I will be ready, you know, to proceed. Definitely. I mean, so, you know, it can seem, we're, as doctors, we're not always as used to being able to do that. But certainly most offices are very, very specific, because good defense attorneys, especially on the PI side, will always walk with a checkbook in hand, literally for that reason. And I've had plenty of PI attorneys tell me that. I bring a check because the last thing I want after all this work it took to get things scheduled is for $800 or whatever it may be to be holding us up, and that's $800 an hour, to be holding us up for a depot. And usually most stocks rates aren't too much higher than that. So, thanks everybody.